purpose does the gentleman from New York seek recognition?
Mr. Speaker, I move to suspend the rules and pass S. 3059, the Courthouse Ethics and Transparency Act.
The clerk will report the title of the bill, please.
Senate 3059, an act to amend the Ethics in Government Act of 1978 to provide for a periodic transaction reporting requirement for federal judicial officers and the online publication of financial disclosure reports of federal judicial officers and for other purposes.
Pursuant to the rule, the gentleman from New York, Mr. Jeffries, and the gentleman from California, Mr. Issa, each will control 20 minutes. The chair now recognizes the gentleman from New York.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material on S. 3059.
Without objection.
Mr. Speaker, I yield myself such time as I may consume.
The gentleman is recognized.
S. 3059, the Courthouse Ethics and Transparency Act of 2021, embodies an important bipartisan effort to address an alarming lack of transparency in the personal financial holdings of Article III federal judges, and the conflicts or appearance of conflicts those holdings can create in the cases these judges are asked to preside over and decide. This legislation makes incremental but necessary progress toward accountability by building on federal statutes that already prohibit judges from deciding cases in which they have a personal financial stake in the outcome. It has been the law in this country since the 1970s that judges must recuse themselves from any case in which they hold a legal or equitable interest of any size in any party or property under consideration. To help ensure that recusals occur as required, federal law often mandates that judges file annual reports disclosing their personal financial interests so that the litigants, press, and the general public can monitor and check these responsibilities. Unfortunately, recent reporting by a Pulitzer Prize-winning investigative reporter and a hearing by the Judiciary Committee Courts Subcommittee have shown that the law is not working as intended. The infrequency of judges' financial disclosures and the inaccessibility of the reports have made actual transparency practically impossible. When the House first passed this version of the legislation last year, an investigation revealed that between 2010 and 2018, over 130 federal judges have decided cases in which they are part owners of the parties before them. Over 60 judges have actively traded shares in entities involved in their courthouse deliberations while their cases were still ongoing, and in some cases, profiting from these trades. At the time, this investigation also discovered approximately 685 cases where judges should have, according to the law, recused themselves. That number has continued to climb and now stands north of 1,000 cases. So far, judges in 836 cases have notified the parties that the case can be reopened because the judge unlawfully failed to recuse. And while these numbers are incredibly alarming on their own, they may simply be the tip of the iceberg. Sorry to say that we can expect that these numbers may continue to grow as more data becomes available and investigations continue. The consequences of these actions are both acute and widespread. Failure to recuse can cause real harm to parties seeking fair and impartial justice and leave a cloud of doubt over any decision that is made once the conflicts are subsequently uncovered. S. 3059 addresses these problems by requiring federal judges to abide by the same periodic transaction reporting laws already applicable to members of Congress and senior executive branch officials. The bill also requires the Administrative Office of the U.S. Courts to create an online database of judicial financial disclosure reports and to timely update that database with searchable sortable, and downloadable copies of disclosure reports as they become available so that litigants, the press, and the public can analyze and access this information in real time. The two versions of this legislation, including the original version passed by the House and the bill currently before us, S. 3059, make two notable changes. First, it makes it crystal clear that these reforms also cover bankruptcy and magistrate court judges. This is a welcome change. Second, in response to concerns raised by the courts, it allows the director of the administrative office of the courts to take more than 180 days to develop the public website and database containing judicial financial disclosure reports, so long as the director provides the Congress with a date certain when the website will launch. We expect that the administrative office will request no more time than a few more months and will not use this authority to delay disclosure. These simple solutions are long overdue and a product of bicameral and bipartisan collaboration. I want to thank Congresswoman Ross for her leadership in this area and Congressman Issa for championing this legislation. I also want to thank my friend Hank Johnson, chairman of the subcommittee on the courts, intellectual property, and internet, as well as Senator Cornyn and the other senators who worked on this bipartisan bill. I urge my colleagues to support the legislation, and I reserve the balance of my time.
The gentleman from New York reserves. The gentleman from California is recognized.